Most people searching for a semi-truck accident settlement number in Florida expect to find one. They don't. Florida semi-truck cases settle for anywhere from under $100,000 to well over $5 million, and that gap isn't random. The trucking company's legal team knows exactly what drives the number. They start working on your side of that equation the same day the crash happens. My name is Doug Burnetti. I'm a truck accident attorney, and I've spent over 35 years fighting these cases here in Florida. What you're about to hear is what I tell every serious truck accident client on day one. By the end of this video, you'll know the specific factors that determine where a Florida semi-truck settlement actually lands, and you'll know what the trucking company is already doing to push yours down. Let's get into it. What the range actually means. There is no average settlement for a semi-truck accident in Florida. What exists is a range, and that range is wide because the legal exposure in these cases is categorically different from a standard car accident. Commercial carriers operating in Florida are required under Federal Regulation 49 CFR 387 to carry minimum liability coverage of $750,000. For hazardous cargo, that minimum climbs to $5 million. Those floors exist because the federal government recognizes that an 80,000-pound vehicle causes a different category of harm. Let me give you some real numbers on that. I had two clients in the same year, both rear-ended by fully loaded 18-wheelers, both with documented spinal injuries that were comparable in severity. One case sold for about $118,000, the other sold for $2.3 million. The injuries weren't what created that gap. What created it was what each attorney knew to go after in the first week. And the single biggest factor in that $2.3 million outcome is something most people who call me never think to look for. The carrier's claims team is assigned to your case the same hour the crash is reported. They know the federal policy structure, the comparative fault playbook, and exactly what your case is worth under best case and worst case scenarios. That analysis is already complete before you've spoken to an attorney in many cases. The average settlement for a semi-truck accident in Florida is the wrong question. The right question is, what factors control where your case lands in that range? And the most important one is something most claimants never think to look for. The defendants nobody names. Most injured people go after the driver. That's the name on the police report, and it feels like the logical target. But in a commercial trucking case, the driver is often the lowest value defendant in the room. Under Florida's dangerous instrumentality doctrine, the owner of a commercial vehicle is vicariously liable for the harm caused by its operation. That liability extends to the trucking company, any leasing entity, possibly the cargo loading company, and in some cases, the truck manufacturer. Each of those parties may carry a separate liability insurance policy. Most claimants never identify them. Let me give you an example of exactly how that plays out. A delivery truck runs a red light and hits a passenger vehicle at an intersection in Hillsborough County. The injured driver will call him James, hires an attorney who names the truck driver only. The driver carries $100,000 in individual coverage. The case sells for $87,000, and James signs the release. When I later reviewed that file, I found that the cargo on that truck had been loaded by a third-party logistics contractor who exceeded the truck's rated weight capacity by approximately 4,200 pounds. That excess weight directly affected the stopping distance at that intersection. The contractor carried a $2 million commercial policy. Nobody named them. James walked away from more than $1.9 million because his attorney stopped at the name on the police report. Now, I'm not disparaging that lawyer. I'm just pointing out that there are a lot of parties you have to have an open mind to and to look to. The trucking company's legal team files cross-claims and third-party indemnification agreements immediately when litigation begins. Their goal is to route any judgment towards the defendant with the smallest policy. They do this before you've had a chance to identify all the parties involved. Get the full chain of custody for that truck. The driver's employer, the leasing company if the cab was leased, the cargo shipper, and any maintenance contractor on record. Every entity with a connection to that vehicle is a potential defendant. The driver's name is the starting point, not the finish line. The federal evidence the carrier controls. Commercial trucks operating in Florida are governed by Federal Motor Carrier Safety Administration regulations. Under 49 CFR 395, a driver cannot operate more than 11 hours after 10 consecutive hours off duty. Violations of those limits create a negligence per se claim under Florida law, meaning the violation itself is evidence of fault. Every commercial truck is required to carry an electronic logging device that records those hours automatically. That device is also the first thing the carrier's legal team moves to control after a serious crash. Here's what that looks like in real life. A multi-vehicle pileup on I-75 near Tampa. The truck driver's paper log shows compliant hours. Clean record, nothing flagged. But when we pulled the truck's electronic logging device, it showed 14.2 hours of continuous operation with no required rest stop recorded. The paper log and the device told two completely different stories. The ELD data survived because we sent a federal preservation demand within 48 hours of the crash. The hours of service violation became the centerpiece of the case and supported a resolution for over $2 million. Without that demand, the electronic log gets overwritten in the carrier's standard 30-day maintenance cycle. The paper log is all that's left, and the paper log said nothing happened wrong. The carrier's in-house legal team sends an internal litigation hold notice the moment a serious crash is reported. The hold covers what the company decides to preserve, not always what you need. Black box data, driver text records, dispatch, communications, and maintenance logs all sit in systems the company controls entirely until a court order says otherwise. Send a written preservation demand to the carrier, the driver, and any connected logistics company within 72 hours of your crash. We like to do it sooner than that. State specifically that you are demanding preservation of all electronic logging device data, onboard computer records, and driver communications. That letter creates a legal duty to preserve what would otherwise disappear. How injury documentation moves the multiplier. Florida does not cap non-economic damages in most personal injury cases. Pain and suffering, permanent impairment, loss of the capacity for the enjoyment of life carry no statutory ceiling in most truck accident claims following the Supreme Court of Florida's 2017 ruling in the North Broward Hospital versus Calaton file. That means the value of a serious semi-truck accident settlement in Florida is theoretically uncapped. But the multiplier applied to your economic damages depends entirely on how the injury is documented from the day of the crash forward. I've seen the gap play out with clients who walked in with nearly identical injuries. One had a neuropsychology evaluation, an independent medical exam confirming permanent C5, C6 damage, and a vocational rehab report projecting over $400,000 in wage loss. That case settled for in excess of $3 million. Another client, comparable spinal injury, had an MRI and 6 months of physical therapy with a 2-month gap of treatment because she couldn't get rides to her appointments. There was no vocational report, nothing on paper about how her life had changed from day to day. That case sold for much, much less than $200,000. The injuries were clinically almost identical. The difference between those two outcomes is the cost of that documentation gap. The insurance adjuster scores every injury against an internal severity matrix that we can't always know exactly what their matrix is, but we know pretty close. Treatment gaps, delayed specialist visits, and the missing diagnostic evaluation each reduce the multiplier by a calculable amount. The adjuster does not call you to explain what's missing. The silence is the strategy. See every specialist your treating physician recommends and keep every appointment. If cost is a barrier, an experienced truck accident lawyer can arrange treatment on a medical lien sometimes. A gap in your treatment record cannot be reversed after the fact. And what isn't documented doesn't get paid. The 72-hour window that defines your case value. Florida statute of limitations for semi-truck accident cases is 2 years from the date of the accident under House Bill 837. That deadline matters, but it is not the urgent deadline. The urgent deadline is 72 hours. Black box data often overwrites on the carrier's maintenance cycle. Skid marks and road evidence wash away. Eyewitnesses who stopped at the scene become unreachable within days. The trucking company's internal communications about the crash are discoverable, but only if they're preserved before the company's documentation retention policy deletes them. The value of a semi-truck accident settlement in Florida is only as strong as the evidence that supports it. Cases that open with a federal preservation demand, a full defendant identification, and an immediate documentation request look fundamentally different from cases that open 3 months later when a claimant finally calls an attorney. Truck accident cases require attorneys who handle them regularly. Federal motor carrier regulations, black box data retrieval, multi-party defendant structures, and FMCSA litigation are a distinct practice from general personal injury cases. The difference in outcome between a general personal injury firm and a firm with active commercial trucking experience is not marginal. In documented Florida cases, it's the difference between a policy minimum offer and a very high, possibly 7 or 8 figure recovery. Write down today's date and the date of your crash. If those two dates are less than 2 years apart, you have time to build this case correctly. Call a Florida truck accident lawyer today, not next week. The 72-hour window on your strongest evidence may already be closing. You now know what moves the number in a Florida semi-truck case. But there's a question almost every injured person asks next, and most attorneys don't answer it clearly up front. What does it actually cost to hire someone to fight this for you? If you walk away without knowing that, you may not call anyone at all. Watch how much does it cost to hire a truck accident lawyer in Florida right now. See you over there.